Be ready. 5 seconds. Start. Notwithstanding anything contained in subsection 1, the last sale or purchase of any goods preceding the sale or purchase occasioning the export of those goods out of the territory of India shall also be deemed to be in the course of such export if such last sale or purchase took place after and was for the purpose of complying with the agreement or order for or in relation to such export. The crucial question is whether the stated sales can be deemed to have taken place in the course of import of the goods into the territory of India before the goods had crossed the customs frontiers of India, which is the core requirement of Section 5(2) of the CST Act. The expression crossing the customs frontiers of India has been defined in Section 2(ab) of the Crossing the Customs Frontiers of India means crossing the limits of the area of a customs station in which imported goods or export goods are ordinarily kept before clearance by customs authorities. CST Act, which reads as this definition, refers to the expression customs station, which in turn refers to customs port, customs airport, and land customs station as defined in the Customs Act. We may usefully refer to sections 210 of the Customs Act as applicable for the present cases, which read as 1. Customs airport means any airport appointed under clause A of section 7 to be a customs airport. 2. Customs area means the area of a customs station and includes any area in which imported goods or export goods are ordinarily kept before clearance by customs authorities. 3. Customs port means any port appointed under clause A of section 7 to be a customs port and includes a place appointed under clause AA of that section to be an inland container depot. For customs station means any customs port, customs airport, or land customs station, and land customs station means any place appointed under clause B of section 7 to be a land customs station. In addition, we may also refer to section 7 of the Customs Act, which postulates appointment of customs ports, airports, etc. The same reads as appointment of customs ports, airports, etc. The central government may, by notification in the official gazette, appoint 1. The ports and airports which alone shall be customs ports or customs airports for the unloading of imported goods. We have no hesitation in accepting the argument of the respondents that being a taxation statute, strict interpretation of these provisions is inevitable. Going by the definition of customs port or land customs station as applicable in the present cases, it is customs port or land customs station area appointed by the central government in terms of notification under section 7. It is not the case of the appellants that the bonded warehouses where the goods were kept and the stated sales took place by appropriation of the goods threat were within the area notified as customs port and land customs station under section 7 of the Customs Act. As the stated goods had travelled beyond the customs port or land customs station at the relevant time in law, it would mean that the goods had crossed the customs frontiers of India for the purposes of the CST Act. Resultantly, the legal fiction created in Section 5(2) of the CST Act will have no application. Notably, the expressions warehouse and warehoused goods have been defined in the Customs Act in sections 243 and 244 respectively. As per the applicable provisions at the relevant time, warehouse means a public warehouse appointed under section 57 or a private warehouse licensed under section 58. Warehoused goods means goods deposited in a warehouse. As aforesaid, there is nothing to indicate that the bonded warehouse where the stated goods were kept by the appellants and eventually sold formed part of the customs port or land customs station. If so, the legal fiction of sale being deemed to have taken place in the course of import of the goods into the territory of India would have no bearing and applicability to the present cases. To get over this position, emphasis was placed by the appellant on the exposition in the Indian Tourist Development Corporation, which had considered the situation where the goods were kept in the bonded warehouse and were made available in the duty-free shops for sale. This court opined that since the goods were supplied to the duty-free shops situated at the International Airport, Bengaluru for sale, it cannot be said that the said goods had crossed the customs frontiers of India. We fail to understand as to how this decision will be of any avail to the appellants, for the court was not dealing with a situation as in the present cases in which the goods had crossed the customs port or land customs station area and kept in the bonded warehouse where the sale by appropriation of the goods was effected as such.